break,
Judge?
we've done some more looking, and in terms of the drone video, I don't want to re-argue it, but I just want to state what happened. When Detective Howard obtained the video, he airdropped it to my phone, which is a lossless type procedure, or at least it didn't change anything. At some point, I emailed it to myself, which did not change anything. It has the file name, the long file name. I did ask Detective Howard to email it to me as well. Then it had the IMG file name that Attorney Wisco received. So somehow in this Detective Howard transmitting it to everyone, if it was emailed, it was compressed. If he airdropped it, it was complete. And that was not known by anyone until a few days ago on Friday.
Well, it depends. This may pass. They haven't asked for it yet. They wanted us to be ready, and of course we're not. But let's take a step at a time. And I just heard their bell ring, so perhaps they have something more of interest to us.
So, Judge, we've been talking. If they do come back with question number 5 or whatever it is, whatever. You have talked about in great detail and length, and it's completely appropriate, the transparency of wanting this to be a fair trial and everything else. And I'm finding that difficult in that one of the linchpins of the state's case was information. Go ahead.
I'm just going to interrupt you long enough to have the material that we've agreed to go up. So if that's ready, Ms. Wisco, we'll have the bailiff take it up. They're ready for the video. I don't know what that means. But let's send up number 4, and then I will hear the rest of what you have to say about number 5. So is that ready to go up?
Yes, I'm having problems with setting it as the default because of the way that I sanitized the computer just now. So if we can go up with the note saying let's play.
Send the note up. Have the DA look at it and make sure it's okay
also,
with them.
If you can make sure they plug the power cord in because the battery is low. It says must play all videos through VLC media.
Okay. Question 4, it's coming up. Yeah, go ahead.
Please keep it open though, so then they don't have to log in.
Yeah.
Thank you.
Excuse me. It's no longer allergies. It's a cold. But go ahead. Yeah, there's no restriction on their use.
So, Your Honor, we were talking during the break, and the reality of it is one of the main portions of the video, the thing that you watched, however many times you watched it, right, on a video that we had the video, not the clarity and not the quality. I think that's been conceded that we did. We were talking about, we would have done this case in a little bit different manner if that was the situation, where we didn't have specific, and I want to say we didn't have the evidence because I don't think that's a fair way to say it, but we didn't have the quality of evidence that the state had until the case had been closed. Had rested, and we were going to open air closings on Monday. We've talked to Mr. Rittenhouse, and I'm going to be asking the court for a mistrial based upon the fact that if we're really trying to get to the heart of it, we've watched the video, I can tell you what we think, but it doesn't matter what we think because we don't get to present that to the jury anymore. And I think if we're going to try to do this in a way that is free from anybody hiding anything, anybody not having the same evidence as everybody else has, where it is clearly a level, fair playing field, we have to ask for this. and I'm asking for it. We understand that it's going to be without prejudice. We understand that the state can redo this case if the court grants it. We understand they will do it again. But then I think we will all have the same information, the same quality of videos, and I think that is required in a case like this where he's looking at a life sentence, potentially without parole if he's convicted. And to not get that until the evidence has already been closed, that doesn't strike me as fair. So for those reasons, I'm making that request.
All right, I'm not going to invite the state to respond yet because the jury has not requested to see number 5, and it'll still have to be addressed because the jury saw it here in the courtroom. But
I'm sorry, Judge, but if I understand Attorney Trofsky's request, this is a motion regardless of what the jury is requesting.
I think we're making that request because it's been shown, it's been pointed out, and in fact, we didn't have access. And I'm at this point, I don't think me pointing fingers and doing that is going to be the end-all, be-all. I think what it is I can tell you, and I think the state can tell you, we got a compressed version, which was not of the quality that they had. We learned that Friday, after the evidence had been closed. We learned that when we tried to play the video for Your Honor, and the state asked that their AV person be brought over to play their video, which was a higher quality. If this is a disorderly conduct or something, I get it. But we're talking about a potential life sentence here. So I'm making that request.
and again, I'm going to say that it has to be addressed if there's a guilty verdict on any degree. That count. Well, even perhaps on the others too. I don't know. It'll all depend on a number of factors. Then the motion will have to be addressed, but it doesn't seem to have the urgency right now until the jury, if and when the jury asks for number 5. That doesn't change the fact that they're making the motion, or that it could affect the case as a whole. But I'm not going to invite your response now until I know whether the jury wants number 5. Does that make sense? If it doesn't make sense, tell me.
It
He was told that they were ready for everything. So, that you have the state's response.
Response invited.
Yeah.
The defendant's first attorney, after he was charged with this case, appeared on an interview, appeared alongside the high-definition version of this footage. I understand he's gone through other attorneys since then, but the defendant himself would have been aware of it. His legal team would have been aware of it. Obviously, both sides have attempted to get it, and we were not able to do so.
What do you mean you couldn't? If you know Tucker Carlson's got it, you could have subpoenaed it, no?
We didn't know that until, I think, today.
No, we knew it.
What did you think it was?
We knew it was aired on his show. We didn't know that Fox News apparently purchased and has possession of it.
Okay. Did you inquire?
We tried to find Brennan.
We tried to find the person who took the footage and who ended up being the person who came to our office with it.
Oh, I interrupted you. Go ahead.
So this is not a video that was in possession of the state in any way, shape, or form. It was out there on the internet and in the world in that regard. And I think we're focusing on too heavily on, I guess, a technological glitch, and less on and we should be focusing that this exhibit was played. The jury is asking to see exhibits that they have seen and that the defense saw when they were played in court. What's on my phone or my laptop or the defense's phone or laptop is of no matter. What matters is the exhibit. And that exhibit was played. It was not objected to. The authenticity was stipulated to. And the defense, I understand they didn't realize it till Friday, watched this exhibit. They watched it on a television set a few feet from them. They could have watched it on the monitors here. That is what matters. That is what the jury sees. That is what they have seen. That they want to see it again is not prejudicial. It's not prejudicial in any way that the defense had a compressed version now. Obviously, they had seen or had a full version at some point, possibly prior to Attorney Richards becoming the primary attorney. But that is not the fault of the state. And the fact that that some technology compressed this file without anyone's knowledge until Friday is not the responsibility of the state. And Defense Exhibit 41 has this video in it. So to pretend that somehow they're surprised or they didn't know about this video, they've tried to find it just as we did. We found it, and there was a technological glitch. Or not a glitch, but I guess it worked in a way that is designed that we were not aware of. And Exhibit 41 not only has the drone video in it, which is the defense exhibit, it also has a circle around someone pointing the gun. As I said in my rebuttal, this did not seem to be a great issue until the defendant testified otherwise on the stand. And now, all of a sudden, the defense is calling into question technology and not wanting videos in, and it's all to protect their client. And I understand that is their job. I'm not criticizing them for this. But their client lied about this on the stand, is the state's position. There seems to be evidence to support the position that he lied on the stand about raising the gun. He was confronted with the exhibit. He denied it. The jury wants to see these exhibits. And I understand there may not be a final ruling on a mistrial until we see what happens or if it's even necessary. And
they had their own expert.
They had their own expert that could have looked at this video, and I'm sure did look at this video, and there were questions at the very beginning of the trial about, and perhaps even before the trial, about the resolution of the FBI plane video, a whole different video. Their expert looked at that. I'm sure their expert looked at this. Their expert must have missed it, that it had been compressed somehow. This is not a resource we had available to us. And I believe the motion for mistrial is inappropriate. I don't believe it should be granted. And coming back to number 5, they're asking to see exhibits that have already been played, and with the exception of the image, exception of 155, were not objected to. And the court has said many times when the state has tried to raise these technological issues, well, there wasn't an objection. And we're asking for the same treatment now, that these were not objected to. The defense has had access to the exhibits. They've had access to the drive, that they didn't realize it and we didn't realize it till Friday. That there was some sort of difference is perhaps unfortunate, but they're also responsible for I'll withdraw that. Anything else? So the state believes that we believe all exhibits should go back. Again, I understand the court has concerns over the still image. I understand that might be in a little bit of a different category, but in terms of question number 5, and while I have the floor, I'll just go through what they are. The FBI aerial with all person of interest marked, that would appear to be the defense exhibit that they neglected to mark and has now been accepted. The state also has one, which is Exhibit 25, which has Mr. Rittenhouse and Mr. Rosenbaum marked, but not the Zeminskis. So I assume they mean the defense exhibit, but we could send both back or have them come down and view it, however we do that. The drone video is 73. That's the full unedited exhibit that's been in evidence now for over a week. The zoomed in still image, we all have talked about that and beaten that horse to death, so I'm going to skip that for now. Then the full event video in regular and slow motion, that seems to be the drone video as that is the only video of incident 1 that was played in slow motion, just as the only video of incident 2 in slow motion was Dr. Black's. So their expert video was submitted. Our expert video is, I believe this is actually 6 videos that they're asking for, which is the drone video. It's spliced out, so it shows the first third of the incident, the second third, and then up until the end of the shooting. And it's in regular and slow motion, and that's exhibits 581, 582, 583. I'm sorry, S81, S82, S83, S84, S85, and S86. And we believe that the jury should have full access to them. They should have full access in this room. And that's our position. I do not believe a technical reality, shall we say, or an unknown technical incident should result in a mistrial.
How would we object?
Pardon me?
How would we object to something we didn't know existed until it was over?
I didn't find that point particularly persuasive because, but anyway.
It's impossible for us to do that. And if everybody in this room that's a lawyer has been a prosecutor. Your job is fairness and being a truth seeker. It's not debatable that it's not fair what happened. We can sit here all day and say it's been played. We didn't know there was another version. How is that reasonable?
Well, I persistently warned the state that, there's a day of reckoning with respect to these things. My feeling is I had my qualms, and I decided, well, I'll let the jury hear it. I think I made the comparison the other day of the breathalyzer, where the officer doesn't have to be familiar with how the breathalyzer does the analysis, but that's a device that has been sanctioned by the courts, and I just don't think we're at that place with this, and particularly if they've got evidence. I didn't see that in your motion about the manual.
We've learned it since I filed the motion.
Well, if they've got the manual, I don't know. It may be. I forewarned you. You've pressed with this, and that's fine. I've let it in, and my view on it now is where we are. We might as well follow through with it. And if they've got everything correct and it's reliable, then they won't have a problem. If it isn't, it's going to be ugly. All right.
I would just note that the defense, I'm assuming they were paying attention to the trial, would have known on Monday when Detective Ventremian testified that that version was different.
We're going to talk about it later because I've made the decision. I'm going to allow it to be played. You've suggested that it be played here in the courtroom under whose supervision?
This becomes the deliberation room for that portion as they watch the video.
I'm going to be in the room with them.
The same people that are in the room with them now.
Well, why come down if they're just going to be looking at? I mean, are you saying that they come down and hear it with all of us in here?
No, I'm saying everyone leaves.
Okay, well, why not just leave them up there?
Because the screen, watching it on the screen that...
I got you.
And that goes, the problem we're talking about on 5 early is the request 5.
Yeah.
We're talking about the
I
problem.
didn't hear the last word you said.
The problem we're talking about on request 5 is on the front end so far, and it goes to the same thing with that television, adding the pixels on the back end. So now they're looking at it on a computer upstairs, and I don't know why they're not looking at this on a computer. Meaning 5. I put my hand on request 5.
Well, and how many times? One time? Is that what you said?
I didn't know. I think just as they're No, I think they should be free to look at it as much as they'd like.
That would be my bias, frankly.
We've laid out.
But we've got the law that you cited the Anderson case. I have ruled in the past, and I'll rule again. The Anderson case is not applicable to images of the event, only to like statements and that types of thing. So, but I'll hear you out.
Judge, I'm relying on the Supreme Court of this state's case. I understand that you're separating them, and I'm just here to tell you that we object to it being played over and over. What I've learned from your case with the videotape or the cassette tape and Anderson, both of those cases talk about not there being an overemphasis on specific parts of evidence.
Possibly overemphasize a video of something, unless I suppose if it's not an accurate video, I suppose then you could. But then you're overemphasizing it when you see it the first time.
That has been the concern of the court in having the jury have just unfettered access to it. In Anderson and in I think it's Franklin, that was part of the concern in both cases.
And I will repeat, I think it's the fact that we have to censor what the jury uses to decide. When the founders of the country gave them the power, it has to be censored by the judge. That's really insulting. So I'm not going to say there aren't cases where a jury could overemphasize something, but for me to say, well, there's a video that is purportedly an accurate depiction of what happened, and you can only look at it so many times, I'm not going to do that. So they know the risk and they've assumed it, and so they can watch it. They'll do with it as they see fit.
Judge, I understand the ruling in the videos. We do not object if the zoomed-in image is not sent with them.
155.
155.
Well, I'm going to leave you gentlemen to confer, and as you did before, and came up with a workable.
How do you wish? Should we put it on a drive and send it to the jury, or are they coming down here?
Why don't you give them a drive, because then they've already got the clean computer to work with to put it on a drive.
We want to use this.
And then they'll come down here, and presumably they know how to work it, or if they haven't told us they can't. They can come down here, and they can operate it from wherever they're comfortable, and we'll all clear out of here. And okay?
I will work on that.
Okay, you confer and come up with an agreement to which you object. A working agreement to which you object. Now let's do the case of the state against Emmett Zier.